Welcome, and thank you for sharing this pretty essential stack of sources with us today.
Glad to be here.
We are diving into, well, quite a collection. Recent legal decisions, some audacious political countermoves, and even visionary reform ideas.
Yeah, and they all seem to circle around this core theme, right? The battle over executive power, checks and balances, maybe the erosion of those checks.
Exactly. So our mission today, as I see it, is to understand not just what's happening in the courts or state houses, but really why it matters. Especially this idea you mentioned, the incentive structure for political compliance.
Precisely. We need to look at where executive power is being, successfully challenged, but also where the system itself, maybe the courts, seem to be failing, which forces people to think about, well, entirely new structures.
It sounds ambitious. We're starting with a surprising look at state-level action fighting federal pressure, then hitting some key accountability moments or failures.
Right. One constitutional, one criminal. And then that radical reform blueprint, Project 2029.
Yeah, and we'll wrap with the big issues hitting the Supreme Court right now. It's a packed agenda.
It really is.
Okay,
Yeah.
Let's unpack this core idea first, the incentive structure. The sources suggest that when the executive branch pushes hard, the target, maybe a university or a state agency, often just caves. Why is caving sort of the default?
Well, it often boils down to a kind of basic political math, The upside to just going along seems high. You avoid immediate punishment, maybe you get some vague promise of future benefits. You avoid a big, messy fight.
And the downside?
Crucially, the downside of obeying often feels low, at least to the person making the decision, because the negative consequences don't hit them directly or not right away. They get absorbed by others down the line.
Right, which brings us to Governor Newsom in California. He seems to have decided to just rewrite that math completely, using a very aggressive tactic.
He really did. The idea was you have to create a massive, immediate negative consequence for complying. Change the downside.
And the case study is fascinating. This federal compact sent to major universities, a 10-page deal for funding, but the strings attached were, well, extreme.
Oh, absolutely. Highly political, you could say radical. Things like forcing universities to bring back SATAC testing.
Yeah, and banning them from considering things like sex, ethnicity, race in admissions, or hiring. And even, this one's wild, punishing academic units that supposedly belittle conservative ideas.
It's astonishing overreach. And here's the kicker, the really key structural bit. Compliance wasn't overseen by the Department of Education, the usual channel for funding.
No, it's the Department of Justice.
Exactly. Which gives them immediate regulatory muscle. They could threaten to cancel federal funding, like instantly for any perceived violation.
So if a department hired a qualified black woman and race was, say, a tiebreaker, that could trigger losing billions.
Potentially, yes, billions gone instantly. That's the threat.
It sounds like straight-up political blackmail. But Newsom's countermove was, I thought, kind of brilliant psychologically. He took their threat and just threw it back.
He did. He basically tweeted, and the source quotes it, "If any California university signs this radical agreement, they'll lose billions in state funding, including Cal grants instantly."
Wow.
And he added, "California will not bankroll schools that sell out their students, professors, researchers, and surrender academic freedom."
So he completely flipped the script. Suddenly, obeying the feds means instant financial ruin from the state.
Exactly. The upside of federal money is maybe vague future stability. The downside Newsom created is immediate catastrophic loss of state funds. It forces their hand. They have to defy the federal demand to survive.
And this idea, changing the downside, the sources suggest it could go much further using federalism, right? Like blue states banding together.
Precisely. Imagine a block of states creating counterpressure. So if the federal government threatens law firms, say, denying them access to federal courts if they don't toe some line,
then maybe 15 or 20 blue states could threaten to deny those same firms access to their state courts if they do comply with the feds.
Exactly. Suddenly the firms are caught. Or think about political compliance for federal officials. What if a future administration promised serious prosecution for things like Hatch Act violations committed now?
So obeying a questionable order today could mean prison time later if the political winds change.
Right. It introduces a serious long-term personal downside. Changes the calculation for obedience right now.
And the most aggressive idea mentioned was states enforcing their own laws against individual federal agents, like arresting ICE agents.
Yeah, for things like kidnapping or burglary if they raid a home without a proper warrant or ID.
But wouldn't that spark a huge constitutional fight? The supremacy clause?
It would spark a fight, absolutely.
Yeah.
But it forces a definition. The Supremacy Clause only protects lawful federal actions. If an agent is acting unlawfully outside their proper federal authority,
Then they're potentially committing a state crime.
that's the argument. And the threat of local prosecution could make agents think twice, maybe even look for other jobs. It changes the incentive for the agents themselves.
Okay, so Newsom shows how you can flip the script politically. But what about the courts? Are the existing tools strong enough for accountability? Let's pivot to that. We have two cases, one showing clarity, one, well, spectacular failure.
Let's start with the clarity. Birthright citizenship seems incredibly straightforward from the Constitution, but it's still heading to the Supreme Court.
It really does seem clear. The 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. That's it.
Right. Historically, the only real exclusion was children of foreign diplomats. Native Americans got citizenship later via statute in 1924. The parents' immigration status just isn't mentioned.
Which is why the lower courts have been unanimous,
Yeah.
right? Saying the president can't just change the Constitution with an order.
Completely unanimous. Judge Gould in the Ninth Circuit was blunt. The president doesn't have power to modify or change any clause of the Constitution.
And the First Circuit agreed, even with a long opinion.
Yeah, Judge Barron wrote like 100 pages, but apparently admitted it wasn't a difficult question. Same conclusion. Yet, the Supreme Court took the case, even with no circuit split.
Why do that?
Well, it's speculation, but maybe it's strategic signaling. If they rule 9-0 against the executive order, it's a powerful performative display of judicial independence. It reassures people they'll uphold the basic text, even in politically charged moments.
Okay, so contrast that clarity with the mess in the Georgia ICO case. This is a huge deal, right? Alleged conspiracy to steal electoral votes, pressure on Raffensperger, fake electors.
Oh, yeah, very serious case. And the sources say they had 4 co-defendants ready to cooperate, to rat on Trump. It looks strong, built on Georgia's tough ICO law.
But then the wonder, a self-inflicted wound, it seems.
Completely. DA Fani Willis hired her then-boyfriend Nathan Wade, and his experience...
Yeah.
Well, it wasn't really in complex prosecutions like this. More divorces, contracts.
Not ideal.
Yeah.
And the result.
The appeals court called it a really bad look. Enough to force Willis off the case entirely. And the judge gave them just 14 days to find a new prosecutor, or the whole case could be dismissed.
Dismissed. Wow. That's a huge win for the defense.
Massive. And the implication, it goes beyond just a bad look. It shows how poor personal judgment, even if not strictly illegal, can create devastating procedural delays. It helps high-profile defendants, slows everything down, maybe chills other DAs from taking on similar fights.
But was the punishment, Willis being removed, proportionate to the bad luck? Or was the judiciary sending its own signal there?
That's the debate, isn't it? Was the error fatal procedurally or just personally embarrassing? The court focused on public trust, but whatever the intent, the outcome delay, potential dismissal shows how fragile accountability can be, even with strong evidence.
Speaking of fragility, corporate accountability also seems shaky. Look at Apple removing the IceBlock app.
Right, the app that crowdsourced ICE raid locations, meant to protect vulnerable people, including citizens who might get swept up by mistake.
And AG Pam Bondi took credit for telling Apple to remove it.
She did, proudly. The app's creator, Joshua Aaron, compared it to Waze alerting drivers about police. He said it was about protection from arrest without probable cause, even invoked Nazi Germany. Pretty strong words.
Yet Apple folded immediately.
Which brings us right back to the start, doesn't it? The incentive structure. For Apple, defying a powerful AG means regulatory headaches, bad PR, potentially huge costs.
While removing the app, the downside is low, affects a relatively small group. Easier to just comply.
Exactly. Avoid the conflict, even if it means compromising on certain principles or user protections. It shows the same dynamic applies across sectors, political, academic, corporate.
That sense of fragility, that the current system struggles with consistent accountability, it sort of pushes you towards thinking about bigger changes, right? Which leads us to Project 2029, moving from reaction to proactive reform.
Yeah, this is Jonathan V. Last's blueprint for a potential future Democratic trifecta. And the goal isn't just winning, it's structural. It's about strengthening democracy itself, pushing power back to Congress, Article 1, away from the executive, kind of authoritarian-proofing the system.
The scope is really something. Core ideas. Making D.C. a state, expanding the Supreme Court.
aggressively prosecuting past lawbreakers to signal impunity is over, eliminating the Department of Homeland Security, new laws limiting presidential emergency powers.
And deeper structural stuff, too, aimed at the mechanics of democracy.
Definitely. Things like ending gerrymandering, maybe proportional representation, a constitutional right to vote for all non-imprisoned adult citizens, strengthening posse comitatus.
That's the law limiting military use domestically,
Right.
requiring governor approval.
Right. And also specifically targeting executive power grabs, like banning the impounding of funds Congress appropriates, no more rescissions.
And critically, allowing a president to be indicted after leaving office for federal crimes committed while in office.
That's huge. It attacks the idea that the presidency grants temporary immunity from accountability.
But the most, maybe radical, idea in there targets the judiciary itself, trying to get rid of those contentious 5-4, 6-3 decisions overturning laws.
This one is really provocative. Embed judicial review the court's power to strike down laws in a statute but add restrictions. Specifically, require a unanimous vote of all justices to declare a law passed by Congress unconstitutional.
Unanimous. Wow. How does the source justify that? That seems like a massive shift.
The argument is it forces judicial restraint. If a law is truly, clearly unconstitutional, shouldn't all 9 justices, liberal and conservative, agree? If it's 5-4 or 6-3, doesn't that suggest the issue is political or interpretive, not clearly constitutional?
So if it's that close, the will of the elected legislature, Article 1, should stand.
That's the theory. It's a direct challenge to the power the court asserted for itself way back in Marbury v. Madison. It aims to return significant power to Congress.
Which sets the stage perfectly for the Supreme Court today. They're back from their 3-month vacation, earning those, $303,000 salaries?
Around that, yes. And Chief Justice Roberts knows the court's power, its legitimacy, depends on the public believing it's fair. That might mean needing some strategic rulings against the executive this term.
Because the docket is loaded with cases testing exactly that executive power versus other branches or individual rights.
Absolutely. If Roberts can't rein in the executive through existing doctrine, those calls for Project 2029-style reforms like court expansion or that unanimity rule, they're just going to get louder.
Okay, let's look at some key cases. Separation of powers first. There's a challenge to using presidential emergency powers for tariffs.
This is huge. The Constitution explicitly gives Congress the power to lay tariffs. Article 1, if the president can just declare an emergency and do it unilaterally.
Then the executive basically gets a massive taxing power the founders gave to the legislature.
Precisely. It bypasses Congress entirely on a core economic function, major separation of powers implications.
Then there's the independent agencies question, the Federal Reserve firing case.
Yeah, the fundamental question is, can the president fire anyone in the executive branch at will, even heads of independent agencies designed to be insulated from politics, like the Fed?
The test case involves firing Fed Governor Lisa Cook.
Right. If the court says yes, the president has absolute firing power over the Fed, well, you could see markets tank. The Fed's independence is crucial for economic stability. Policy needs to follow data, not political whims.
And due process comes up again with immigration.
Yes. That case challenges ICE raids where people, sometimes including U.S. citizens, are arrested and shipped off without basic procedural rights. No Miranda warnings, no lawyers, no judge.
So does the government have to follow fundamental rules even during immigration enforcement?
That's the core constitutional question the court has to answer.
Then we have the social rights cases. Voting Rights Act in Louisiana.
Right, a challenge to a map with 2 majority black districts brought by white residents claiming they faced racial discrimination in the map drawing, a complex VRA issue.
And some really emotionally charged ones, too. Trans athletes, conversion therapy.
Yeah, the case involving trans girls on field hockey teams, and another challenging a Colorado law that bans therapy aimed at changing someone's sexual orientation. These put the court right in the middle of intense social debates.
Finally, we have to acknowledge that context, the potential perception of ideology. The sources noted the previous administration won, 18 out of 22 recent emergency docket cases.
That kind of win rate, yeah, it raises red flags. It looks potentially ideological, which is incredibly damaging to the court's legitimacy.
And the long-term danger.
It's about stare decisis, the principle of respecting precedent. If the court keeps overturning prior decisions, especially seemingly along ideological lines, it starts to look like law is just, the personal opinion of a past court.
And the public stops seeing them as objective arbiters.
And starts seeing them as just 9 unelected politicians in robes. That erodes the foundation of their authority.
Wow. Okay, so we've gone from state governors playing political hardball and changing incentive structures through accountability failures in courts and corporations, looked at a pretty radical blueprint for democratic reform.
All while the Supreme Court is sitting on cases that could fundamentally reshape presidential power, agency independence, and basic rights.
Yeah, it's quite a landscape.
What's really fascinating is that tension, between the immediate political moves, like Newsom's tweet clever, fixes a specific problem, and these much bigger, long-term structural changes proposed in Project 2029, like that unanimous review idea.
And the Supreme Court's decisions this term could really push things one way or the other.
Absolutely. They'll signal whether the existing constitutional framework is seen as strong enough to rein in executive power, or if pressure for really fundamental structural reform becomes, well, maybe inevitable.
It leaves you with a heavy thought. If the highest court keeps chipping away at precedent, at stare decisis, treating past rulings as just, well, disposable opinions, what's left? What foundational belief, beyond the Constitution's text itself, can citizens rely on to keep faith in the stability and fairness of the rule of law?